Hello everyone, my name is Andy Turner and welcome to our webinar. During today's discussion, we will be discussing the Patent Trial and Appeal Board developments that have had a meaningful impact on IP litigation in 2019. If you have any questions during the webinar, please type them into the chat box and we'll be answering everyone's questions at the end of the webinar. After the presentation, a recording of this webinar will be available on BK's website in the Media Center. Let's get started.
So with that, we were going to briefly introduce ourselves. I'm Sangeeta Shah. I'm the CEO of Brooks Cushman and also the co-chair of the Post-Grant Proceedings Group.
I'm Andy Turner, and I'm the other co-chair of the Post-Grant Proceedings Group. My practice focuses on post-grant work and also patent prosecution.
And I'm John Rondini. I'm part of the litigation group, also the co-chair of the cybersecurity and data privacy practice here. And I also work a lot in the post-grant proceeding practice.
All right, so here's an overview of what we're going to talk about today. So first, under the PTAB practice procedure section, first, the PTAB has been busy taking care of some housekeeping and setting up some kind of formal procedures. So first, they released a consolidated trial practice guide last year, and they released an original trial practice guide in 2012. And then since then, when there's been, in the trial practice guide, it's kind of like an MPEP for AIA trials. It's a good reference material. But since then, whenever there were updates, there were new cases, new doctrines, they would issue an update that was only limited to the sections they were changing. So it became a little complicated over time to have all these different documents. So they finally consolidated those, and that's quite helpful. Next up, the PTAB established a precedential opinion panel, or the POP, last year, and this group, which includes Director Iancu and some other people at the PTAB, they determine whether a decision is going to be designated or not. They can de-designate decisions, and also, when you request a rehearing, you can request that the POP panel reviews it. So, for example, if there's a certain issue that you think is kind of a global issue that should go to their attention, you can ask for POP review. And it's a pretty easy process. We actually requested one last year, and it's just that you send an email and you kind of frame your issue. Next up, for hearings, most of the hearings are in Alexandria at the main office, but they have a lot of satellite offices now. And sometimes you can actually request your hearing on an IPR at a satellite office, which I think they only do that if one of the judges is actually sitting there. But another interesting feature that the satellite offices will offer is that you can remotely view a hearing at another office. So if your hearing's in Alexandria and maybe you're not presenting or you just want to view the hearing and you're near one of the satellite offices, you can contact the office and just set up a remote viewing. And it's a pretty easy process. I actually did this a few weeks ago for a case that I don't represent any of the parties to, but it's even for research. And you can, as long as they're not using the hearing room for anything else, you can go and they'll set it up, and it's quite helpful.
So yes, in our case, this is easy because we have access to the Detroit Patent Office.
Right.
That's a nice mechanism for us to regularly access these kinds of hearings.
Yeah, and it's a lot closer than Alexandria.
DC.
But even all the other satellite offices offer this too, so Denver and Silicon Valley. Next up, which we're going to talk about this in a few minutes, but we're going to go over some of the PTAB stats. And we're going to look at some of the recently designated decisions, and then we're going to kind of focus on the discretionary denials here. And then we're going to get into the post-grant claim amendments. So there's a new pilot program for amending claims through IPRs, and we're going to go discuss that, and then also compare it to amending claims and reissue and re-exam. So then we're also going to discuss some of the constitutional issues.
Yeah, primarily we'll talk about the Arthrex decision, which came out last October. Two other decisions, that came out as well last year, but the big one that everybody's talking about right now is the appointments clause under the Arthrex case, and a follow-on case that, has been arguing the same thing, the Polaris case, which is also in reference to the appointments clause. And then the last thing we'll talk about today is the federal and statutory issues.
So there's two cases that we wanted to touch on there, two schools of thought. One has to do with petitioner estoppel and kind of the recent case law with respect to that, and kind of the ongoing saga with respect to real party and interest, and the latest case law that helps further define real party and interest analysis.
So now we're going to move on to the stats.
So with this slide 5, this is a snapshot, I think it came from Jack and Napkin, indicator that shows you just another one of these trends of what's going on year over year with respect to, in this instance, mainly the movement areas with respect to IPR filings. So you can see, there was a high point of IPR filings in 2017 where there was 1,723 IPR filings. Since then, there's been a relatively significant reduction of IPR filings, obviously almost 500, a reduction of approximately 500 from 2017 to 2019. Most of that we account for several things. One is there's been a lot of movement with respect to reducing serial petitions, things we're going to be talking about, discretionary denials, has led to just changing behavior in the number of petitions that get filed. So that's one big area. We also think that, the percentage of institution decisions that are denied, generally speaking, also modifies people's behavior in terms of the number of IPR petitions that they would file in the first place. Conversely, if you look at the CBMs and PGRs, they're somewhat flat. CBMs are getting phased out statutorily. PGRs, again, are kind of at steady state. And we're going to be talking a little bit about why that is when we look at the estoppel implications later on in the discussion.
All right. So now the next slide here, we're looking at IPR institution rates. So this looks at the institution rates since 2013. And one interesting point here is that the institution rate has been relatively within a small window here. It's between 60 and 65% over the last 5 years or so. So we see little dips here and there, but it's relatively steady. So next up, we're going to talk about some of these recently designated decisions. And when we go through some of these doctrines that have been developed, it's kind of important to look back and say, okay, what are some of the goals of the AIA? And here in this, we talked before about the Consolidated Trial Practice Guide, but this cites in a few different places, some of the legislative history. So here, post-concurrent proceedings are meant to be quick and cost-effective alternatives to litigation. So then if these are some of the goals of the AIA trials, then we look at how some of the statutes were developed to kind of further these goals. And for quick, 314 and 316, they include specific provisions that kind of specify IPR timing, 1-year time frame from institution to final written decision, and then the 3-month window between patent owner preliminary response and institution decision. So that kind of frames the, kind of the 1.5-year timeline of IPRs. Cost effective, and there's a number of doctrines that have developed that kind of are directed to this efficiency and fairness of the AIA trials. And these are kind of in a number of different provisions of statute, 314, 16, 25, 312. A few years ago, we used to talk a lot about redundancy, vertical redundancy, horizontal redundancy, and that doctrine has kind of been phased out. But there's plenty more. Some new ones are being developed, multiple petitions. We're going to talk a little bit about serial petitions, parallel petitions, prior examination doctrine, and then also some of these lack of particularity. And then also, when we talk a little bit about alternatives to litigation, this also out of 314, there's kind of a somewhat newer doctrine that has to do with parallel litigation, so litigation in parallel.
So with respect to the multiple petitions that Andy was just talking about, there's two basic buckets that they fall into. There's the serial and the parallel petitions, and under either one of those, the boards basically come back and said single petition per patent is generally sufficient, to balance the fairness, timing, and efficiency concerns under 316. The guidelines that they provided last year don't foreclose the possibility of instituting on multiple petitions for the same patent, but it's going to place the burden on the petitioner now to explain why more than one petition is needed per patent. So basically, it's really putting the focus on the petitioner. It goes back a little bit to the horizontal and vertical redundancy arguments that the PTAB originally developed back in the early 2013, 2014, 2015 period. Essentially what they want to do is they don't want you to come with multiple grounds. They want you to put forth your best ground. They want you to put forth the best art. They don't want to have to dig and sift through various arguments and permutations of different arguments in order to figure out what your argument is. They want you to put it forth in one petition and make it very clear. I mean, a couple of exceptions that they've basically focused on is if there's a patent where the patent owner has asserted a large number of claims, the patent has,
mega patent.
Yeah, mega patent where, generally per petition, although it's not a rule or it's not stated anywhere, it's, usually about 20 claims per petition is what you can fit in, argument-wise. Sometimes more, sometimes less, depending on the claims, depending on the redundancy between the claims. But if there's a patent that has, like Andy mentioned, a mega patent that has 40, 50, 100, 200 claims, the PTAB is generally recognized those are exceptions to the rule, so the petitioner will have to file multiple petitions, not so much to attack, but to address all the claims that are being asserted. The only other exception that they've really kind of come out and discussed is the priority aspect. What I mean there is if there's a dispute about the priority date of the patent and what would be considered prior art and what's not considered prior art, the PTAB has generally allowed multiple petitions, one where you might have a reference, depending on where the priority date falls, may or may not be a prior art reference, and then you might have another petition where you clearly have references that are prior art no matter what the priority date is. So under those circumstances, those are the two exceptions for these multiple petition attacks that the trial guidelines have tried to set forth in the last year. With that, when we're talking about serial petitions, 2017 General Plastics case is still a precedential case, and it's still followed by the PTAB, and it's mentioned for the factors, the 7 factors that it listed in there, when you have serial petitions, and the PTAB has to look at it and make a decision whether or not follow-on petitions should be denied. They follow one of these 7 factors. They'll go through, they'll look at them. So if you're a petitioner, you're going to have to address these and explain under these factors why you're filing more than one petition. So this is something you got to keep in mind when you're handling your petition. You're going to have to go through and address these factors. Now, what came out interesting last year was the 2 new precedential cases, the valve cases that came out, and there was 2 valve cases here, valve 1 and valve 2. And this case began with a patent infringement lawsuit in the Northern District of California, where Electronic Script filed suit against Valve Corporation and HTC, asserting 2 patents, the 934 and 935 patent. Here, the HTC filed 2 IPR petitions, one against the 934 patent and one against the 935 patent. And the PTAB granted institution for HTC's petition against the 935 patent. And then what happened was Valve Corporation requested to be joined as petitioner, and the PTAB granted that request for the 935. So that right there is valve 2. Now for valve 1, with respect to the 934 patent, HTC's petition against the 934 patent was denied institution. And after the denial, Valve went and filed 3 more petitions against the 934 patent challenging the same claims. And Electronic Scripting came back and said the PTAB should deny those petitions since they were unfair follow-on petitions. They were serial petitions, and they had cumulative grounds, and they were attacking the same patent as the HTC. So you have 2 different scenarios here, they're similar, they're all based out of the same lawsuit, but fact patterns are a little bit different for each patent. So with respect to valve 1, the 934 patent, the PTAB went back, they applied the general plastics factors, and they followed factor 1 essentially here, and they said there was a significant relationship between Valve and HTC with respect to the 934 patent because both were co-defendants in this underlying district court litigation, and their interests were clearly aligned. And the PTAB stated that Valve knew the prior art references that it was now trying to bring forth in the 934 petitions, and knew those from the district court litigation, but it waited till after HTC's petition was reviewed and denied before it went and filed its petition. So the PTAB reasoned, since there was co-defendants here, they were essentially the same petitioner, and this was a serial and repetitive attack, and so they denied the Valve petitions under factor 1. So under valve 2, again, this is one where Valve had asked to be joined to HTC's petition after it was instituted. So the PTAB, looking at this one, said, wait a second, Valve, you're already, quote-unquote, a petitioner with respect to an already instituted IPR proceeding, so therefore you can't come and request another follow-on petition. That's a serial attack. So they denied it not only under the fact that they were a co-defendant, as discussed in valve 1, but also because there was a petition that was instituted. They asked to be joined as a co-petitioner. That was granted, so therefore, now that they're a petitioner, they can't go and file these repetitive attacks against the same patent. So the big takeaway with these 2 precedential opinions that came out last year is if you're a co-defendant, if you're a part of a litigation where there's multiple defendants and you know of art, you can't wait until some other co-defendant goes and files a petition. It either gets instituted or denied before you go and make your request, file your petitions. You're going to have to start considering this early on, and if you're going to go file petitions, you got to keep this in mind that you could be found to be a serial petitioner, and your petitions could get denied under the general plastic factors, in accordance with Valve 1 and Valve 2.
So for right now, though, John, is it safe to say that it's unclear when there's no relationship between petitioner 1 and petitioner 2, if the serial petition?
Right now, that is, yeah. So right now,
discretionary denial would apply.
yeah, just if there's, unless it can be shown that there is at least some relationship, then yeah, I think you're probably still safe. But in cases where there is co-defendants, it's going to be argued under, the patent owner is going to argue the Valve cases where there's co-defendants and try to get them denied under these Valve precedential opinions.
The timing is a big factor here. So they look at, they don't want you to use an institution decision as
a roadmap.
A roadmap.
Right.
Which it goes back to their earlier decisions from a couple of years ago where, they wanted to stop these serial petitions and they said you can't use our decisions, you can't use a denied decision from somebody else as a roadmap to clean up and come and attack and file new petitions with the same art.
Right. So it all gets to the underlying fairness issue.
Exactly.
The patent owner should file one petition, do your best job, surgical strike, patent owner responds, but doesn't have to handle serial petitions.
Exactly.
Then the same petitioner or another petitioner can't fix any errors, right? That's any errors that might be identified.
Which is kind of what happened here with the Valve cases, is you had the denial and, they came back and they were trying to quote unquote fix it, use the roadmap aspect and fix it, and file several more petitions. Even though there was some new art, it was art they knew about. So to your point, Sangeeta, it all gets back to, the fairness aspect. They don't want to overburden the patent owner with multiple attacks against the same patent.
Right.
So, with all this push, these serial petitions and denying serial petitions, patent owners decided that this new strategy was, if you file all the petitions on the same day, they can't be in series, right? So that's, over the last few years, that was kind of a new approach where you would see petitioners filing multiple petitions on the same day. And sometimes even when there was like joint defense groups, this could be quite a few petitions challenging the same patent filed. So this is kind of a new doctrine from the PTAB. So this, in the middle of last year, in one of these trial guide updates, the Patent Office had a section on parallel petitions. So here, the board says if you're going to file 2 or more petitions challenging the same patent, they said the petitioner should identify a ranking of the petitions and then explain what's different between the 2 of them. And then it's expected that petitioners will do this. So now that's, petitioners might not want to identify certain art that's maybe deficient. So this could be one of the reasons why we see a little dip in the IPR, the petition filings from last year. Petitioners are kind of consolidating into one more cases. So again, kind of a takeaway here is if you have a lot of different grounds, you might want to pick the best one, run your best art, and that kind of similar to what John was just saying for the serial petitions. So next up is prior examination. So here, historically in litigation, defendants have tried to avoid challenging patents over cited art that's cited on the face of the patent. And this is, courts, typically give a lot of deference to the patent office, to the examiners. Well, this is a little different at the PTAB, and with the judges here, they will typically evaluate a number of different factors to determine if the art or arguments in the petition are similar to those evaluated by the examiner. So that's by this provision, that's 35 U.S.C. 325B. And you can see from all these different factors, they compare, so even if it is a cited reference, maybe the examiner never considered it. Maybe they missed it. Maybe there's some type of error. So all these different factors kind of go into the art and the arguments and how they're similar between the petition and the examination. And then also if you've identified any examiner error. What did the examiner miss? And then also, so that was the factors. There's a precedential decision here, which is the Becton-Dickinson case. They actually designated that decision twice. So first they designated it as informative a few years ago for the whole decision, and then last year they came back and designated just the factors as precedential. So here, in the whole decision, an interesting point here is in Beck and Dickinson, they actually denied institution based on the prior examination of the challenge patent's parent application. So that's something to consider when you're challenging a patent. Look at the file history of both, the challenge patent, but also any related patents, parent application. And the other thing to keep in mind, these factors, along with the general plastics factors, were that in the trial practice guide, they list these as non-exclusive factors. So that's just something to keep in mind, that these are, we saw with the bail cases, they're willing to expand some factors in certain conditions, certain situations. They're non-exclusive factors. So next up, parallel litigation.
So this is another area that the Consolidated Trial Practice Guide created some clarity on the issue. Obviously, in IPRs, the vast majority, I don't know the statistic offhand, but it's at least 80+% of IPRs also have parallel litigation at the same time. And so in this instance, the Consolidated Trial Practice Guide has specified the basis for discretionary denials depending on kind of the stage of the parallel litigation in relationship to the IPR. So this harkens back to, Andy was kind of initially going through the relationship of the various statutory provisions. Several of them link back to efficiency, cost effectiveness, and is the IPR actually an alternative to litigation? So this sort of, nicely ties up a lot of those provisions in the form of the specific provision in the PTAB. And that's then kind of further explained. There's a good case, this NHK versus Interplex case, that specifically talks about, again, timing, right? What's the state of the parallel district court litigation in relationship to the IPR? Various kind of critical litigation trigger points. What's the stage of Markman? What's the trial date? How far along are we in the litigation continuum? And how does that then relate to the parallel IPR trial? And, is it really going to be, is there an efficiency that's going to be had, or are you really just duplicating your efforts, in which case, there's a more than sufficient basis for the board to deny based on the inefficiency associated with that. So one thing to note here is that, practically speaking, the two things that seem to get the most amount of play with respect to this analysis is, has claim construction completed, and what's your trial date? So, of course, the claim construction, that's relatively easy to figure out when that's actually complete. The trial date, as obviously in litigation, that date gets sort of jostled around a fair amount, depending on any number of factors. It's possible that at the time that this analysis is being done, you may have a trial date that ultimately gets pushed out. So it is something to keep in mind that if you think that there are factors that may modify the current trial date, you certainly do want to identify that, because the existence of a trial date alone should not be a dispositive issue, although it's certainly something that gets a lot of consideration in this kind of analysis.
Seems like the trial practice guides are basically following what district court proceedings have been following the last couple of years about judicial efficiency and trying to just streamline the cases so that you don't have multiple attacks against the patent in multiple different venues.
Right. Yeah, absolutely.
One interesting point here is we were representing patent owner, and we were running an NHK argument because we had a trial set before when the final written decision was. So we raised that in our patent owner preliminary response. And it looks like, although the board has not established factors for this yet, they actually issued an order, and they asked us about 15 different questions related to, different points in the litigation, whether there's invalidity contentions out there, different factors. So like they were maybe floating potential of future factors. So we listed an example at the bottom. So here's something, just a reference point, that different things that the board is considering.
Based on that case, yeah.
But it seems like they're kind of like different factors they would consider, they're not kind of unique to our case. It's
right.
More of when you have an IPR in parallel with litigation, different milestones in each, just to...
Yeah. More detail with respect to the scheduling order so they can really understand the state of litigation.
So next up is lack of particularity. So here, under 35 U.S.C. 312, petition must identify in writing and with particularity each claim challenge, the grounds on which the challenge is based, and the evidence. So it must identify claims, grounds, and evidence with particularity. And then in the trial practice guide, they say, okay, the party should avoid submitting this repository of all the information that judge could consider. So here we have a case, a recent case that was designated informative. It's this Adaptix case. And here, we see that, maybe in response to some of the multiple petition doctrines we were talking about before, now petitioners, they are trying to get a little more creative and trying to cram more grounds into the petition. And in Adaptix, I think they only listed like 3 or 4 grounds, but a lot of them, they had multiple references, like A, B, C, and or D. And so you see this a lot now in petitions where they have kind of these alternate type grounds with or without D. So once you maybe list 3 grounds, but if you kind of unpack all these alternate combinations, really you're more at like 8 or 9. And then sometimes in these petitions, for all these alternate combinations, maybe the petitioner doesn't explain all the different rationale to combine these. Some of them are somewhat conclusory.
And that's usually the area that gets short shrift,
Yeah.
right? Is the individual rationale to combine for each ground.
So with that, basically the board they denied this based on these different grounds. And basically, so the takeaway there is, don't try to cram too many grounds in the petition, or kind of in layman's terms, don't try to put 10 pounds of ice cream into a 5-pound bucket. So also, when we talk about particularity with respect to evidence, so here's a recent case. This was actually this Hulu case, which was decided by the POP panel. And this had to do with public accessibility of prior art publication. And then we're not going to delve too deeply into the facts here, but basically the POP kind of avoided creating any bright line rule with respect to the amount of evidence necessary to prove public accessibility. But they did, this decision did provide some kind of useful examples of what was sufficient, what is not, and when a petitioner can supplement evidence during the trial.
So the big takeaways, I guess, when we're talking about these different fairness and equity standards that the PTAB and the board are kind of looking at is, the board is basically looking at, fairness, timing, and efficiency concerns under 316 to determine if multiple petitions should be warranted, if they should be granted. The guide doesn't foreclose, again, the possibility of instituting on multiple petitions, but it's going to place that burden on the petitioner. So as a petitioner, you need to have a story, why the patent being challenged is bad or requires multiple attacks. And that fact pattern should typically align with the doctrines that we've discussed here today for serial and parallel attacks. I mean, if you're going to file serials, you're going to have to consider those general plastic factors. If you're filing parallels, you're going to have to think about the different types of grounds you're bringing forth, how you're bringing them, and whether or not the board is going to look at them and say, no, these are parallel attacks and it's not fair to the patent owner, the timing is not good, efficiency concerns by bringing, like Andy just mentioned, grounds A, B, C, and or D. I mean, these are things you're going to have to consider when you're filing your petitions. You're going to have a story, you're going to have to address the factors, you're going to have to address all these different issues in your petition. And this is something a couple of years ago petitioners didn't have to do. You just try to cram as much into your petition to attack the claims as possible. Well, that's not the case anymore. Now you have to, if you're going to do multiple petitions, you're going to have to address these factors, and then you can put your grounds in there. You're the actual meat of your petition. So it's just something you're going to have to think of as a petitioner when you're going after a patent.
Flip side, while the petitioner is focused on painting this narrative that the patent itself is a quote bad patent, worthy of an unpatentability decision, the patent owner during the pre-institution phase, you get the petition, you're taking a look at it. Your entire goal is twofold, right? It is to, number one, again, in accordance with these goals and the PTAB's current increased desire to really look at the basis for discretionary denials, you want to really look for opportunities to take the petition and put it into the unfair petition bucket by casting it as an inefficient use of the board's resources or perhaps district court resources, depending on the state of IPRs versus district court litigation, that it's not fair because there's parallel petitions or some other, the arguments were presented previously, or, again, it's that you haven't particularly brought out the specific grounds that you've challenged, you've just sort of floated them, but they haven't been discussed in sufficient detail to really warrant analysis. And so you really want to hone in on the procedural bases for discretionary denial, because this is your best chance to take a really good, have a really good attack on the procedural grounds and use that as an opportunity to, kind of end the entire matter through a discretionary denial. And then, of course, you want to couple that with your best shot on merits. right? Like, what are the issues that are coming up? If there's, just a straight out deficiency that exists, hopefully not heavily fact laden, because that is something that'll likely get you into trial if there's sort of a mixed issue of fact that you have to look at. But if there's a fundamental legal issue that you want to raise based on how, again, that the rationale to combine, for example, is deficient, if there's some priority or something else that comes up that you can raise that's a defined legal merits issue, it's nice to wed that, to marry that with the procedural ground. And then, you have a really nice, strong patent owner preliminary response to help potentially move the needle towards an institution denial.
And then just something to keep in mind that, we've discussed a few of these multi-factor tests, but the board likes kind of non-exclusive factors, and they like creative arguments. So if if a fact pattern doesn't exactly align certain factors, just keep in mind that the board in some cases will expand those factors. So if your fact pattern is close, you should still address it, petitioner and patent owner.
So one thing I guess we should say is kind of comparatively over the span from 2012 to now 2020, the pendulum is definitely sort of shifting and has continued to shift towards the PTAB is very responsive to reasonable arguments that identify flaws in a petition that can lead to a denial. So, both petitioners need to be kind of more surgical and more focused in their presentation, and patent owners have a real opportunity, if they can find flaws, to, properly address them and bend the board's ear to militate in favor of a denial.
All right, so next up, we're going to talk about post-grant claim amendments. Some of the different options, whether it's IPR, reissue, or re-exam. So first is kind of, this data is from September of 2018. This is when the Patent Office did kind of an extensive study on motions to amend at the PTAB. And you can see here, not that many motions to amend are filed. I mean, some of these 49, 50 motions a year. And we saw earlier that, petitioners are filing over 1,000 a year. So this is relatively a small number of motions to amend. I'll give some of the more specific numbers. So the total AIA trials as of September 2018 were over 4,000, but only 416 motions to amend were filed. And then here, so as of September 2018, okay, there were 416 filed, there were 90 that were pending, and 326 were completed trials. So of this 326, only 205 where the motion to amend substitute claims were decided. Kind of the reason between that discrepancy there, that difference, is motions to amend are typically filed as a contingent motion to amend. So first the board's going to evaluate the original claims, and then only if those claims are all found unpatentable, then does it go to the motion to amend. So it's contingent, so the board doesn't always get the motion to amend. But so of those 205 substitute claims that were decided, those different motions to amend that were decided, only 8 were granted, 13 granted in part, and the vast majority of them were denied. So the Patent Office was looking at, as part of this study, they're like, how can we improve the system here? Because this is not really working out. This is not a good option for patent owners. And actually, we represented a petitioner in one of these cases under kind of the old system. And a big problem here is after patent owner files a motion to amend, they don't really receive any feedback. Under the old system, there's no feedback. You file a motion to amend, and then the first time you really get any feedback from the board is when you're at the hearing. So in our case, when we got to the hearing, there were just so many issues. You had all of your original claims, and then once the motion to amend, you had a variety of issues, some like threshold issues like public accessibility, all the way to rationale to combine. And basically, from this study, the Patent Office kind of came to the same conclusion that it would be helpful if we gave patent owners some feedback ahead of time. So that's basically, there's this motion to amend pilot program that went into effect last March. And kind of the big change here is, okay, when a patent owner files a motion to amend, they can request preliminary guidance, which is feedback from the board. And then once they receive this preliminary guidance, then they can say, okay, they can either just file a response, or they get an opportunity to amend claims again by filing a revised motion to amend. So that's option 2. And actually, there's two additional options. Option 3 would be the patent owner doesn't even respond, after receiving the preliminary guidance, or they could withdraw their motion to amend. And why, that does happen sometimes, because when you file a motion to amend, you kind of open the door to additional challenges to the IPR process. So in a petition, normal IPR, in a petition, you can only challenge claims under 102, 103 over patents and publications. But once a patent owner files a motion to amend, then petitioner can challenge these claims under 112 issues, under 101. It kind of opens the door to additional challenges. So maybe these other options 3 and 4, which I don't show on the slide, maybe patent owner doesn't realize they have all these 112 issues, and after they receive preliminary guidance, they want to withdraw. So next up, this slide, this basically shows the timeline under option 1. And what you see here in blue, this is the preliminary guidance. And on the top, we have the normal timeline where we're arguing the original, petitioners challenging the original claims. And then if patent owner files this contingent motion to amend, basically you have parallel briefing. And, that's kind of the old system. Under the new system, now there is this preliminary guidance. So now option 2, there's additional briefing. So now you see the first blue box, this is preliminary guidance. Then if patent owner wants to file a revised motion to amend, there's additional briefing in here. And as you can see, between these two parallel tracks, there's a lot of briefing in a short period of time. And also with this option 2, it actually bumps out the oral hearing to 12 months. So you saw in option 1, this is kind of normal timing. The oral hearing is 9 months after the institution decision, 3 months before the final written decision. And under option 2, if patent owner does file a revised motion, then kind of come to account for all this additional briefing, they bump the oral hearing out. So now, we're going to look at, okay, what does this preliminary guidance look like, right? So here's one from one of these cases that's ZTE versus Sideways. And so the preliminary guidance, first, kind of the threshold, the board is going to look at statutory and regulatory requirements. So here in this case, they said patent owner appears not to have shown a reasonable likelihood that it satisfied these requirements. So first, they'll look at reasonable number of substitute claims. And here, does patent owner propose a reasonable number? And there's a presumption that a reasonable number is a 1-for-1. You have 5 claims, you're going to propose 5 substitute claims. It's not like the old re-exam days where you can get, 100 claims. It has to be kind of 1-for-1. Next, does the motion to amend respond to a ground of unpatentability? So does the claim amendments, are they related to the issues here in the IPR? So in this case, yes. Next up, does the amendment seek to enlarge the scope of the claims? So here, you can add limitations, you can't broaden claims. So in the motion to amend, you can't strike out a bunch of limitations to try to make it a broader claim. It has to be more narrow. And next, new matter. So this is what I was talking about before, the 112 issues. So here, does the amendment seek to add new subject matter? And in this case, they said, yes, it does. They tried, so the board, this is why it did not statutory and regulatory requirements. So now, after going through these, the board will go on to look at patentability. So then here, they will look at, okay, these substitute claims, would they be patentable? So here they found that one of these claims would be unpatentable for obviousness, and then other claims would be unpatentable for indefiniteness. So here, claim 23 would be obvious, 23 and 24 would be indefinite. So this is just kind of illustrates that, okay, based on this type of feedback from the board, now the patent owner could decide, do they want to further amend the claims? One, you could address the new matter issue, maybe you could narrow the claims to address some of these other issues.
One thing really quickly to note with respect to the issue of definiteness, that while the board can provide feedback with respect to the definiteness issue for claims that are going through this motion to amend practice, actually just this month there was a ruling from the Circuit in the Samsung versus Prisua, I think, Prisua case, Prisua Engineering, that kind of under no set of circumstances can the board provide indefiniteness ruling. They can kind of address ancillary issues related to indefiniteness for purposes of looking at anticipation or obviousness, but they can't definitively make a ruling on indefiniteness by statute. So
For the new,
it's just
For the old claims.
For the old
for
claim.
the challenge.
Yes, so
But
that's
they
something
actually, in that
to keep in
decision, they
mind.
distinguish between
The old claims
That's-
and the,
That's right, yeah,
So
so
the-
that's an important point to note, that what this sort of provision where the board will give you feedback on indefiniteness and a variety of other things only applies to substitute claims.
right, and I don't think there's a decision yet where it's been decided whether or not they can actually rule 112 issue on the substitute claims. That hasn't gone up yet, but.
Right.
Well, that's actually in one of our, when we get to the cases to watch, there's one where that is.
It's coming up.
Yeah.
And the other thing, just flipping back real quick here, is, just a historical thing to remember is this whole, new, guidelines that they're providing for these motions to amend is nice, because historically you used to get 5 pages to try to cram everything into, doing. So when we're looking back some of those historical stats that Andy brought up, a lot of those fell under that 5-page requirement where you had to cram everything into 5 pages. And a couple of years ago, the board recognized that as an initial issue with these motions to amend. And so these new guidelines, these new practices that they're putting forth are really helping to allow the patent owner some flexibility in amending the claims. And to Sangeeta's point earlier, we're starting to see a pendulum shift, not only in terms of, not everything just getting instituted and killing all the claims and having the high, quote unquote, death rate on these patents, but the patent owner definitely has some ammunition on how to attack and how to address a lot of these issues, and now possibly how to amend their claims when an institution is granted.
So next up, here's some stats on the new pilot program. And again, this hasn't even been in effect for a year yet, but basically, to date, patent owners have filed 51 motions to amend under the new program. And for these cases, 20 preliminary guidance. The board has issued 20 preliminary guidance. And of these, about 65% of the patent owners, they've won on those statutory and regulatory points. And then, but only about 5% of patent owners won on both. So here, for the cases that reach the next stage where patent owner acted on this feedback, 13% just filed a reply, 80% filed a revised motion to amend. So this is kind of, you can see that the patent owners kind of appreciate this feedback and they are revising their claims. And then here's one, looks like some patent owners didn't even withdraw here. So this first final written decisions on these cases filed under the new MTA program are going to be due in April. So these are going to be some of the cases we'll list later for cases to watch. And with this additional briefing in a short period of time, there's different things to consider when managing cost and complexity. You can file a non-contingent motion to amend, so basically eliminate one of these tracks. You want to, because you might have additional declarations from experts, you want to try to schedule your depots in advance, and you can even, if there's a lot of issues, you get to oral arguments, split the oral argument. So next up, we're going to compare the IPR amendment process to reissue and review.
Frankly, this slide could be, a whole webinar unto itself, so we're going to take this in a really compressed way, just to introduce some of the opportunities for how some of the differences in terms of what do you do when you want to amend claims post-grant effectively, right? Assuming, of course, you may or may not have an open family. So if you take a look at this, we kind of walked through, Andy just went through the explanation of the motion to amend practice in its current form, especially with the kind of twist to the pilot program. And here we've got, the ability to kind of cross-compare that with reissue and re-exam. I guess the primary things to note, because we're going to kind of do it at a high level, is timing, right? You have, well, several different things. The threshold. Let's focus on the threshold. So you have statutory thresholds and specific requirements that Andy just went through on the IPR side. To reissue, you have to identify an error. It used to be much higher of a burden to have to identify a, quote, defect associated with the underlying patent. That was the threshold to get into reissue. Now they've substantially lowered that, and it's effectively a form that you check. So the threshold for reissue is quite low. Re-examination, you have to identify a substantial new question of patentability. That is certainly a higher threshold than reissue, but not, but certainly one that with the right patents and publications can be achieved. Then if you look at kind of the issue of which of these is actually impacting the 1-year time bar, of course the IPR doesn't. The re-examination equally can be filed. So let me clarify, right? The re-examination can be filed before an IPR, it can be filed during an IPR, and it can equally be filed after an IPR. There's actually a case that we were involved in, IXI, where that specifically tests out that proposition of what's the impact of a reexamination that's filed after a final written decision. So that case sort of lays out this proposition. So you've got, some timing provisions that exist there with respect to the three different options. If you look at the scope of review with respect to an IPR, of course, it is sort of fundamentally limited to as we talked about, 102, 103 effectively. In limited instances when you're, and of course, 112 when you're looking at the substitute claims. With reissue, it is anything. It's looked at as the same as original prosecution. So anything that the original examiner could have done, any rejections they could have found during original prosecution, the same sort of rejections can be put forward in a reissue. With the reexamination, they do not look at 112. Because you're in reexamination, you're narrowing the scope, looking at the originally issued claim, whatever the breadth of the broadest original issued claim, you have to narrow from that. And so based on that, they don't look at 112 in view of the original examination that took place. In the interest of time, I won't go through every single one of these, but obviously another critical factor here is the fact in IPR, motion to amend, of course, that's an inter-party proceeding. So you have, of course, the PTAB as well as the petitioner that are involved in the motion to amend sort of process. That is clearly not the case with reissue and reexam that are both ex parte. Cost varies, and a lot of that depends on kind of how it's structured, how robust of a reissue and reexam you engage in. If you hire experts and have declarations, the cost can increase. And the pace of this also sort of changes as a function of, are there going to be appeals on the IPR side? Are you just looking at the motion to amend by itself? Reissues and reexams generally take about a year today. Both of those are handled by the central reexamination unit. And so the timing of those historically was much longer, but generally today you can expect 12 to 15 months to have those resolved. There's a lot of layered strategies that you can employ using reissues and reexams, and like I said, that's kind of a separate webinar, but there's a lot of really interesting things to consider when you want to consider amending some or a large number of claims and how to go about using one of these three mechanisms to proceed.
So moving on, and I know we're running short on time here, so we'll try to get through these last couple of slides. The next issue is the constitutionality issue, and I know many people have probably on top of heard of the Arthrex decision. Essentially that October decision held that the judges, the APJs, have been improperly serving as principal officers because under the U.S. Constitution's appointment clause, there's only two types of government officers: the principal officers, who must be appointed by the President and confirmed by Senate, and inferior officers, who can only be appointed by heads of departments. The decision held that the APJs had improperly been operating as principal officers, and they didn't have enough supervision by the director to be considered inferior officers. Interesting about this case was Arthrex didn't raise this during their PTAB proceeding. It was first raised on appeal. Judge Moore, Chen, and Reyna decided that this was an issue of exceptional importance, so the question was raised during the appeal and was something they addressed. Since that time, since that October decision, both parties have basically, and the U.S. government, has asked for the full Fed Circuit to reconsider the panel's decision en banc. And there was a January 3rd notice sent out by the Fed Circuit saying they wanted responses from all the parties by January 17th. And as of January 17th, all the parties have answered and basically argued either, this issue, obviously one side is saying they're inferior officers, one side is saying, the government saying, this is something the Fed Circuit shouldn't even be addressing, and then the other side is saying that, the officers are the correct type of officers. So that whole issue is starting to percolate back up, and not only percolate back up with respect to this case because it's being asked to be considered en banc, but you have a parallel case, this Polaris case, where Polaris did raise this issue about the appointment clause at the PTAB trial. It has gone up to appeal, and they have had oral hearing on this one. And essentially, Polaris, during the oral hearing, argued that there needs to be an effective mechanism by the executive branch to review these PTAB decisions, and what's in place right now is not effective, and that the IPR system, as it stands right now, should be found unconstitutional until Congress can enact laws that address this judicial appointment and some type of an executive review by the executive branch, very akin to how the ITC proceedings operate, where the ITC, you have ultimate review by the president, the head of the executive branch, since this is an executive appointment. So in the Polaris case, that's what they're arguing. It's similar to what Arthrex is now arguing, or what the parties are arguing the Arthrex case during the en banc proceedings. And what a lot of people are thinking is that these two cases are kind of going to run in parallel and merge, and there's going to be one ultimate decision that comes out of both of these cases. And although people originally said Arthrex wasn't proper because it wasn't addressed at the PTAB level, Polaris did address it there. So this decision probably will be decided one way or the other in one of these two cases or both these cases together.
So next we want to turn to the issue of petitioner estoppel. This is one that more recently has been getting traction, largely because, the fundamental issue is once you've had an IPR decision, a final written decision, what's the scope of then the estoppel implications for the petitioner? By statute under 315, it's technically any claim or ground the petitioner raised or reasonably could have raised during the IPR. In the very beginning, back in 2012, this gave people a lot of pause. Over time, it hasn't been viewed as having, significant teeth, and at least in the first few years of, from 2012 to let's say 2016. More recently, there's been splits in jurisdictions, which is part of what we're showing here. That, you can see kind of, NDCal, for example, had a relatively narrow view of the scope of 315. And conversely, previously, Texas, Virginia, Massachusetts, for example, had a much broader reading. And NDCal, over time, as you can see, kind of post-SAS, seems to have gradually shifted to the broader interpretation column of the scope of 315, which is also consistent with this Asatac Denmark case, which equally, again, another NDCal case that tracks what we're talking about in terms of the kind of pendulum shift at NDCal with respect to the scope of the estoppel, that effectively any ground that reasonably could have been raised by a petitioner is stopped. Then the petitioner is stopped in litigation to then raise that ground. So this is something that we'll be tracking to kind of generally watch trends with respect to jurisdictions and their, the scope of the estoppel implications for IPR petitions.
And also you can see the impact here as it relates to PGRs. So PGRs, you could challenge claims under 112, 101, a lot of different issues. So that's probably the reason we're not seeing a big increase in those filings is petitioners are concerned with the petitioner estoppel. So here are our 2020 predictions. Our predictions here for IPR filings, we think these will still decrease, especially for some of these multiple petitions we talked about before. PGR filings will probably remain low unless there's a change in the way district courts interpret the petitioner estoppel.
Not likely, but
Yeah.
fair.
I don't know if there's I don't know if I've seen these.
No, PTRs has always been low, will
Yeah.
remain low. Not a lot of action there.
We'll probably see PTAB will expand some of their discretionary denials, develop some new doctrines. And, it'll be interesting to see what happens with these motion to amend if the PTAB actually ends up the grant rates increase. And if they do, then the motion to amend filings will probably increase. So there's probably a link there. And then as far as Arthrex,
It's unknown at this time. I mean, the PTAB could release some solution, but that solution could be overturned at the Fed Circuit level depending on not only the Arthrex case, but the Polaris case. So that's just a case to watch. Both those cases are cases to watch, and it'll be interesting to see how that constitutional issue is decided.
over the last few years, there's been a lot of motions to transfer venue out of places like Edie, Texas, back to California. And, those might decrease now that petitioner estoppel has a little more teeth in California. So here's some cases to watch.
The first one is click to call, and that case essentially brings up the issue of agency review, appellate review. This is in the context of institution decisions that are predicated on time bars. And so for that specific case, raising the issue of when it's pending cert review to whether there's any form of an appellate review for these institution denials that are based on a time bar. So that's just interesting because otherwise there's no appellate mechanism at all for those kinds of decisions. So that's certainly one that's going to be closely tracked this year.
Next up, the Hunting Titan case. This is one that's before the POP panel. And here they just had the hearing a few days ago, but they're examining whether the board can create its own reasoning for rejecting patent amendments. So this is one thing where the board will actually look to the record and sometimes come up with their own reasoning for these substitute claims, and they're we're gonna see if they can actually do that. And then the last cases here, these are some of the first cases where patent owner filed motions to amend under the pilot program. They received preliminary guidance, and then they filed revised claims. So these would be interesting ones to watch to see if the board ends up granting these claims. Thank you for listening to our webinar today. The slides will be made available to view on our firm's media center in the coming days. And feel free to contact Sangeeta, John, or myself with any future questions. And we look forward to hosting another webinar for you soon.
Thank you.
Thank you all.